All right, Steve, we are good to go.
Good, thank you, Brian. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict of interest. That said, and seeing no conflicts raised, I'll welcome everybody to the last Zoom meeting ever of the State Bar, I hope. Probably not, but we'll all be together soon, I'm happy to say, and looking forward to seeing everyone in person in Nashville next month. I imagine everybody's gotten a chance to look at the agenda, and it consists of just approval of the subcommittee meeting minutes first from February 17th, and there was a very thorough job done by Brian, and see you helping with that, didn't you, Brian?
Liza also helped. Liza assists, yes.
And if I could have a motion to approve those minutes.
Move to be approved.
Second.
All in favor?
Aye.
Aye.
All right, the minutes are adopted. Today we have the better part of 90 minutes, as much of that as we want to use, talking about the rule on anti-discrimination language and whether or not to include that in our rule 8.4, as many other jurisdictions have done. Brian's going to start us off with a short update on what is happening or not happening, as the case may be, in Pennsylvania concerning Greenberg v. Haggerty, where their rule was challenged. And then we'll get into, I guess, pick up our discussion where we left it before we went to preamble, and get into what would a rule look like if we had one. And I think as part of that, we're going to revisit some of those hypotheticals, which I found instructive, and I know several other committee members did too, in terms of whether or not a rule is needed, why is it needed, do we have rules that address the kinds of conduct that we looked at in those hypotheticals, and then we'll try to figure out where we're going from here. So Brian, what's going on in Pennsylvania?
Great, thank you. Well, just wanted to, before we even touch on Pennsylvania, want to remind everybody, not just here on the subcommittee, but those that are potentially watching this on the live stream, that we do have that proposed amendment to the preamble out for publication. You can find the language on the State Bar's website as well as in the State Bar Journal. The comment period is open now. So if anybody wants their comments to be heard, they can submit them to ethicscomments@ncbar.gov. And they will be before the Ethics Committee at the July meeting. There's also that proposed new comment to Rule 1.1 on competency, which addresses implicit bias and the role that awareness of implicit bias and cultural differences plays in the representation of a client. So those are pending and presumably back before both the Ethics Committee, Executive Committee, and the Council at the July meeting. With regards to that Pennsylvania case, this is going to be a really short update. The last time we spoke, the Pennsylvania State Bar had appealed the ruling issued from the district court in Pennsylvania, and they have since abandoned their appeal. So the district court's decision stands. Of course, the district court granted the injunction on prohibiting the enforcement of that rule, or their version of an anti-discrimination rule in Rule 8.4. So they've since abandoned that, and we are left to our own, I guess, our own devices. So that's I don't think there's really any other questions on that. So I'll pause briefly if anybody has questions.
Have you talked with anybody at the bar to know why they abandoned the appeal?
We have not. And Carmen, I don't know if you're privy to any other discussions that occur through the National Organization of Bar Council. I've been trying to keep an overview of that, but I have not seen any sort of additional explanation.
I have not either. They may not wish to comment further.
That'd be my guess. So with that said, Steve, we can simply go into the kind of the bulk of our program here, or our agenda today, as far as kind of rehashing where we are and going into these next steps.
Yes.
Okay.
Mhm.
All right. So Carmen, did you want to take over at this point?
Sure, I'll just do a little introduction. Just as a reminder, way back in October was when we went through a series of hypothetical factual situations and had the subcommittee weigh in on whether they believed each of those sets of facts should potentially result in professional discipline. And then we talked about whether there were existing rules that already covered those situations. And we discussed some of the challenges that might exist just on a practical level for prosecution. So we are today gonna, come back to those hypotheticals, and I'll talk a little bit more about that in a minute. But first, before we go back to the ones we've already seen, Brian is going to walk you all through a few new hypotheticals that are derived from an actual North Carolina case. And so just to kind of get us back in the mode of trying to think about these fact patterns and whether we think there should be a rule that governs them. So let's do a few new ones to warm up first.
All right, so we're going to do just what we did in November. I'm going to launch a poll after reading the hypothetical, and the question is, does this warrant professional discipline? We got a lot of great feedback from this activity as we try to center our attention on exactly what this rule is intended to cover. So this first hypothetical is in a group text message with a law clerk and an appellate judge. Lawyer makes profane and inappropriate comments about another law clerk, including comparing the law clerk to a member of the terrorist group ISIS. The question to you all is, does that conduct warrant professional discipline? I'm going to go ahead and launch the poll right now. It's a simple yes or no. I see voting has slowed down. Looks like 9 of the 11 folks have voted, so I'm going to end the poll right here. And we are at a 5-4 split in favor of this being discipline. This is a 5-4. 5 people said yes, this does warrant professional discipline. 4 folks think that it does not.
And can I ask you a question?
Yes.
What context? Like, are these people friends? Are they texting about a case? Are these I'm trying to figure out if it's within a professional context or not.
It is. It's I guess it's these are all coworkers, and not necessarily just personal friends. They're coworkers, okay. And they're talking about another member of the chambers.
Okay.
So this one actually does have a bit of a twist, and I'm going to go ahead and relaunch the polling. I don't know if this changes anything. Sometimes I think our minds automatically go to a particular conclusion as to what's going on here. So again, knowing that both lawyer who's committing the conduct as well as the law clerk who they're referring to are both white, does that change your answer? Does that warrant professional discipline? See, the votes are starting to slow down. And so I will end the polling here. And now we have a slight swing. We have a 5-4 split saying, no, this does not warrant professional discipline. 5 people say, no, that doesn't warrant professional discipline. 4 say yes. I'm not gonna spend a lot of time on these ones. You guys all know what we're doing here. So we're gonna go to the next hypothetical because I think we're gonna talk about all the different implications of these hypotheticals in the next segment. But want to go with another one here. This is the next hypothetical. In a judge's chambers, lawyer belittled others and used fear and intimidation while interacting with and supervising law clerks, including referring to female law clerks as bitch or bitching.
I recognize this.
No comment, Alan. So Here's the, does that conduct warrant professional discipline? I see some of the polling starting to slow down. If anybody wants to throw a vote in, feel free to. All right, I'm going to end the voting here. We are at more of a split. 8 people say this does warrant professional discipline, 2 say it does not. So this is an 8-2 split in favor of professional discipline. The last hypothetical for our warm-up here is hypothetical 16 here. While employed by an appellate judge, lawyer told a female law clerk on a cold workday while working outside that he would like to see her in a wife beater tank top and shorts on a cold day. Does that warrant professional discipline? I think this one is making us think a little bit longer. I'm seeing some voting coming in, and it looks like it's starting to slow down. I'm going to end the polling there. We are at 7-3, 7 in favor of this being professional discipline, 3 saying that it should not warrant professional discipline. So we have a, this is actually from a case here in North Carolina, like Carmen said. This is a case out of the Judicial Standards Commission in Reed Murphy from late last year. And it was really concerning an employee of a judicial chambers. And I think it became that question of looking at that. This wasn't the judge's conduct that was at issue. It was somebody employed by the chambers, but that individual was not actually a licensed lawyer in North Carolina. But it brought up the question, if this was a licensed lawyer who engaged in this type of conduct in order as prominent as a judicial standards order, would the state bar be able to take action against that lawyer, and what rules do we have to serve as a foundation for any sort of disciplinary prosecution? So with that said, that's our warm-up. Carmen, do you want to take it from here?
Sure, Brian. And actually, let me just interject one thing on what you just said. The only precedent I'm aware of that might be relevant to the question you just posed is there was a case in which the public defender in a county was engaged in a lot of workplace sexual harassment, and the state bar did take action on that on the theory that someone who is employed within the judicial system who engaged in that behavior, that behavior was then prejudicial to the administration of justice. So I think that's pretty specific to public sector employees in supervisory roles, perhaps, but that might be analogous to the situation you just described. All right. So what we're going to do today is we're going back to the hypotheticals that you're familiar with from the last time we did this exercise. But what Brian and I did for an almost embarrassingly long amount of time before we joined you all here was try to figure out what components of the rules that exist, or components of the rules that could exist, should we select in order to reflect the subcommittee's opinions on whether or not these various factual situations should be governed by the rules of professional conduct. So if you remember, in one of our meetings, there were a bunch of brightly colored charts that basically showed all different options for components of a potential rule of this kind. And so Brian and I went through and did some picking and choosing amongst those components in order to hopefully show a rule that reflects the opinions of the subcommittee. And when we talked about it at the beginning, we said it will be interesting to see whether whether the result is something coherent that could potentially be worked with and refined, or if it's just a Frankenstein's monster of administrative rules that really isn't workable. And so I think maybe we landed closer to something coherent, but we'll see. So we're going to go through the hypotheticals first, and then at the conclusion of that, we will show you the sort of final amalgamation of what we came up with based on the subcommittee's thoughts about these hypotheticals. Okay, let's do this. Hypothetical number one. it was unanimous among the subcommittee that this type of behavior by a lawyer should be actionable under the rules of professional conduct. This type of behavior is sort of one of my specialties within the Office of Counsel, and I will tell you that I don't believe it is currently actionable the way the rules are constructed. So we actually decided after some consideration that this really didn't fall under other or within a definition of sexual harassment that would be useful for other types of misconduct, and that really this was very unique to the attorney-client relationship and abuse of the fiduciary relationship there. And so it probably, if we want to prohibit this, is better situated under Rule 1.19 that prohibits sexual relationships with clients. And so at the end, we'll show you, this is, we wandered off the path a little here, but we agree that this probably should be something that the state bar can address, but we think it's probably better situated in 1.19. So we'll show you what that might look like at the end.
And then hypothetical number 2, again, we had a pretty strong vote in favor of this conduct warranting professional discipline. What we looked at here, just kind of what would be needed in a rule to cover this conduct. And this is where we start kind of getting to those components. You all will probably remember, I believe back in November or maybe October of last year, Carmen put together a really great summary of the different aspects of these different rules that we see across the various jurisdictions, including different states of mind, how they describe this type of discriminatory conduct. Is it conduct that's manifesting bias or prejudice or engendering bias, knowingly, intentionally, reasonably should know, things of that nature. And so with that said, we looked at this, kind of taking the cue from the vote here, that if a rule were to cover this type of conduct, that it would really need to be a rule that references conduct that's manifesting bias or prejudice. And that, as for state of mind, we're talking about a know or should have known standard. Carmen and I discussed the different aspects of, whether it's something that is intentional versus known and things of that nature. And we landed on, and pretty solidly on, this know or should have known standard. The question here that I think maybe is not for today's discussion, but maybe a later discussion is, the bias and the discriminatory categories. We've got this particular example is really a comment on someone's sexual orientation, as well as a physical characteristic. And that's something that I think maybe the subcommittee would want to take a look at later, as far as, these comments, this conduct that is demeaning to other individuals, and what categories we want to include in the rule. So that was that's hypothetical number 2. Carmen, you want to take number 3?
Brian, can I interrupt just a minute?
Yes, please.
If we can go back to hypothetical number 1, I want to understand, Carmen, did you say we can address that conduct now under 1.19, so we wouldn't need a new rule to do that?
No, unfortunately, what I said is I don't believe this conduct is currently actionable under any of the existing rules. I mean, I'm sure I could cobble something together creatively if necessary, but it is not clearly addressed by any of the existing rules. However, if it were to be addressed, we believe the best place to add it in to clarify that this conduct is unacceptable would be in Rule 1.19 by way of amendment, not by way of a new rule.
But I'm sure that.
Thank you for that clarification. The Iowa court relied on their new rule under 8.4, didn't it? To basically say it was just it was sexual discrimination, not necessarily sexual conduct.
I understand. I understand that could be done. I think the way we have ended up parsing sexual harassment versus discriminatory conduct in our final product, our definitions wouldn't be exactly the same as the court that addressed this elsewhere. Also, I think, the issue here really is the exploitation of the power dynamic between lawyer and client. it's not so much an issue, I don't think, of discrimination. I mean, it could be that the lawyer enjoys getting nude photographs from male and female clients, and then where would we be, right? It's still inappropriate. So
It's harassment, right? Okay, thanks.
All right, so Carmen, you want to take number 3?
yeah, so hypothetical number 3 took us into the hallowed halls of law schools, and this hypothetical was fairly well divided, at least the initial presentation among committee members, about whether or not just sexually explicit commentary or sort of suggestive compliments by a law professor to a law student should be actionable. The hypothetical, when modified a little bit to include unwanted touching, then it was clear that the subcommittee thought that should be actionable. So I will say just at the outset that unwanted touching is always, if we can prove that, that's actionable already. I mean, that's a criminal act. That's a violation of Rule 8.4b. We don't need to do anything in order to make that scenario covered under these rules. So this is one where it was sort of equivocal, I think, or a pretty close split among the committee members about what you would like to do with this. What we have done is come up with a proposed definition of sexual harassment that would include scenarios where sexual overtures, commentary, conduct of other kinds that persisted after it was clear they were not reciprocated would be actionable. And so it's a little ambiguous whether that would cover this situation. The rule we propose would cover a situation where this kind of conduct was ongoing when it was obvious that it wasn't being well received. You know, I think it's arguable that in the academic context, the employment consequences for a professor would address a single instance of this kind of behavior, and that really in protection of the public becomes more of an issue when it is clear that it is a persistent behavior and ongoing problem. So we felt like we kind of came up with a compromise there on our definition of sexual harassment.
Carmen, whether reciprocated or not, doesn't the relationship that exists, whether it's teacher, student, attorney, client, make that conduct inappropriate, whether reciprocated or not?
It does. I mean, I think, again, the power imbalance is the critical piece. However, unless we wanted to carve out an entirely additional section of the rule that speaks to those types of relationships, it's just hard to fit within a more generalized definition, I think.
All right, so hypothetical number 4 introduced the issue of really what constitutes legitimate advocacy. You remember this one is where a lawyer basically offers an absurd sort of explanation or defense, just argument in representing a client that is irrelevant to what the situation or the issue is at hand in the case. So once again, we are looking at something that this is conduct that's manifesting bias or prejudice. We are seeing that recurring sort of theme or indication here. One of the things that Carmen and I were talking about was what rules cover this type of conduct already, and really 4.4 and 3.1 already apply. I mean, as far as 3.1 and just the notion of the prohibition on asserting any sort of frivolous argument, but really but 4.4 as far as doing something that has no substantial purpose other than to embarrass or burden an individual. But I think this is where, you know, this could be a moment of clarification and really still being careful to craft a rule that does recognize there may be a time for legitimate advocacy for good faith assertions that are grounded in law. This example was not one of those, but that it's still something to be mindful of in terms of crafting some type of rule, particularly to avoid any sort of overbreath challenge or something of that nature. So coming up on number 5 here, Carmen.
So number 5 was also, I think we had some interesting discussion and debate about this, and the subcommittee ultimately came down on the side of no, this shouldn't be a matter for the state bar, which I think is probably the appropriate outcome, particularly because any conduct of this nature that constitutes a true threat, again, would be a criminal act, which we can regulate, which we can address. But short of that, I think it is our collective advice as your lawyers that this kind of political speech, even if it's intensely hyperbolic and offensive, really has such a heightened First Amendment protection and is outside the wheelhouse of the state bar, such that trying to regulate it is not. We just don't think that's a good idea. We think it's inappropriate and would subject the rule to fairly legitimate constitutional criticism. So, here the elected official at issue happens to be a lawyer, which makes it feel a little closer to a professional act. But truly, I think distilled down, this is a political act, and that's just not something we need to be regulating.
Where do those quotations come from, Carmen?
Yes, I'm sorry. So the 2 bullet points on the screen, these new pieces are these are comments, or I think these are both comments or sections of the proposed rule. So this is part of the language that Brian and I have in our current proposal, and these 2 are not new. These were co-opted from other versions of anti-discrimination rules in an effort to limit their application or scope.
Yeah, and to that point, just so everyone is on the same page, Carmen and I have been kind of working out exactly what some sort of proposed draft would look like, and I emailed that version to you all before this meeting, not for you to study, but just so you'd have it when we get to that point in the discussion. After we go through these hypotheticals, we're going to talk about how everything kind of fits together and show you our work in progress. Going to hypothetical number 6, this was another situation where the subcommittee was pretty clear in saying that this type of conduct should not be covered by a rule. This should not be subject to professional discipline. We're talking about a presentation at a CLE where somebody is offering some type of, again, kind of a good faith argument, an assertion in the law that essentially just because they have a controversial opinion about a case or a development in the law, that doesn't necessarily warrant somebody to professional discipline. So that's where you'll see here that the quoted language is something that you're going to see in that proposed rule as a part of a comment. But again, looking at composing some type of rule, it was clear that the subcommittee felt that those sorts of legitimate CLE activities really should not be included or not subject somebody to some type of professional discipline, really to enable that continuing education responsibility and continue, kind of challenging of each other in the legal context.
Well, and Brian, am I right that one of the major arguments in the petition challenging the Pennsylvania rule was the way in which it would chill or curtail presentations at CLEs?
Yes, that's a great point. It's the main argument. That was what the opinion focused on, and the petitioner's request for an injunction focused on the nature of his business and his practice, which is really in representing, I think he represented or worked for a nonprofit, or just gave a lot of different CLEs that where he used a lot of controversial terms, a lot of just controversial things in CLE presentations. So that's where this is something to kind of be mindful of as we navigate this composition water. Hypothetical number 7, Carmen.
This one is very quick. Everyone agreed this should not be subject to discipline. This kind of conduct has never been subject to discipline under any version of any state's anti-discrimination rule. No jurisdiction has suggested that lawyers are compelled to undertake any client or cause. And the quoted commentary that's on the screen has existed, I believe, in pretty much every version of this rule that we've seen. So this is a non-issue. This was already taken care of.
This next one is kind of an interesting one because We had a similar one in our warm-up, a similar sort of fact scenario with a vote that was slightly different. We came out this morning 5-4 in favor of this being professional discipline, but under this particular hypothetical, the subcommittee voted yes, it should be subject to professional discipline, but it was 9-1. And again, we have this this issue, conduct that's manifesting bias or prejudice. It's appearing yet again. But the thing that Carmen and I kind of went around about is this notion of when the audience of this comment is receptive to this type of conduct, what sort of professional discipline implications or considerations do we need to take into account? Essentially, if the tree falls in the forest and no one is around to hear it, does it really warrant professional discipline? So perhaps this requires we were looking at the I guess Rule 4.4 and looking at the prohibitions that are currently in place, which really focus on conduct or prohibited conduct being that which has no substantial purpose than to embarrass, delay, or burden a person, but to perhaps amend 4.4 to include demeaning a person, because that's really what this is. You might have a very receptive group that is I guess just all about whatever you are saying, but if there's no substantial purpose other than to demean that person, that's really the harm that occurs within the profession. Like in this situation, you've got a lawyer that's telling a client whether the lawyer thinks the client is or is not receptive to that particular comment. That comment is demeaning of another individual in the profession and is certainly not helpful and not something that I think the subcommittee wanted to I guess tolerate. So that's hypothetical number 8. I don't know, Carmen, I probably butchered my explanation there. So
no, I mean, I think that these are the most challenging types of hypotheticals to try to regulate, because yeah, we just it's hard if the person against whom the bias or prejudice exists is not present. We have to figure out how do we describe that conduct. It's easy if it is directed at a person or a group of people in a public space, but in a private space, and when the target of the hostility is not present, it's a little bit more complicated. So we tried to address that through Rule 4.4 by changing the language in there a little bit, and you may or may not think that works, but that was our best solution.
Brian and Carmen, along the same lines of the person not being present, is there a distinction between a lawyer saying something like this to a client and a lawyer saying something this to a colleague and a lawyer saying something like this to the court? I mean, is there any distinction with who the audience is, whether or not the person being disparaged is present or not? I mean, for my gut reaction is if our job at the State Bar as a self-regulating organization is to protect the public, our greatest concern is anything involving the public, right? Which would be clients. But I don't know that we distinguish. I don't know that we need to distinguish, but I read this hypothetical differently than I read the other one. And I think implicitly it was my desire to protect the public that made me read them differently.
I think
Good point.
Yeah, Amy, I think you're hitting on the thing that really Carmen and I spent the most time talking about. It's scope. And really the notion that context means a great deal in looking at these rules and looking at the conduct, how you put those contextual concerns into a rule is incredibly difficult. That's why this is all still very much a work in progress and an ongoing discussion. But I think that's something that the subcommittee, would be worthy of our time to discuss that very aspect. And you'll see in the upcoming hypotheticals towards the end, there's another situation where there's this conversation amongst friends, or at least an email conversation that was supposedly private using government resources, but nevertheless, brings in that very issue of who is the audience and the potential damage that can occur if it gets leaked out. So it's a great question, Amy. I'm not sure that we have a great answer for it. All right, Carmen, hypothetical number 9.
Yes. Indeed. We decided this was an even split. This is clearly an employment decision by a lawyer that is based in an immutable characteristic, and there was an even split about whether that warrants discipline. The way that we split this baby was to indicate that employment discrimination would be actionable as a disciplinary offense if it actually met the legal definition, I guess primarily under Title VII, so as defined by existing law. And then we also included in the rule an additional limitation indicating that that type of employment discrimination would actually have had to have been adjudicated by the appropriate tribunal before the state bar would address it as a rule violation. That second part isn't necessarily required. I know that Catherine Jean would prefer that we have it in there so that the Office of Counsel doesn't get into the business of litigating Title VII, in the first instance during disciplinary cases. But that was the best compromise we could come up with, given the division within the subcommittee. We can address this, but it is most workable to address it in a way that is limited to existing law.
Right. I'll just add a slight clarification as far as what you all have in your materials. We didn't include that adjudication requirement in the proposal, but I think that was a question that we wanted to pose to the subcommittee, unless maybe it got taken out in the midst of our flurry of drafts, but I don't think it's there. But it's something
I thought it was there either way. That's an option. I thought it was still there, but
yeah, and I think that's the question to this subcommittee of is that required? And I know there's a number of jurisdictions that do require it and others that don't require it. I know Illinois comes to mind as one that requires adjudication before they actually find that to be actionable under their rules. All right, hypothetical number 10. This was once again, we're kind of getting into the issue of conduct that occurs in a more social setting. And it was really clear from the subcommittee's vote that, again, unanimously saying no, this type of conduct where a lawyer is making these kind of unwanted advances at a social function, that should not be subject to professional discipline, but that when you introduce the power dynamic into the equation, that did warrant professional discipline. Specifically, when we're talking about a male lawyer who is a partner making these advances towards a female lawyer who is an associate, or when you have a lawyer who's making those types of advances towards a paralegal. So again, we're in a situation where those second two, or I guess the second and third sort of descriptions there, those are really tied to applicable law. I mean, that I think would constitute harassment, and it's something that would be actionable under current law. But then it also brought up this notion, like I said before, this question about social functions, and that I think the subcommittee expressed the opinion that social functions really were more or less off limits, that essentially acting in professional organizations with regards to official business would be one thing, but engaging in these different types of, I guess, conduct, these comments in a social function while completely unprofessional is not something that necessarily warrants professional discipline. All right, number 11. Carmen, you're on mute.
I'm ashamed. Same thing here, really same issue. We included a definition of acting in a professional capacity that excludes purely social activities of professional organizations, just in order to cut this entire context out of the regulatory space. Also, as I mentioned earlier, our proposed definition of sexual harassment wouldn't cover just a single instance of inappropriate drunken propositioning. It would require a repeated behavior that was inappropriate. So that's how we address this hypothetical.
And this hypothetical, I think it generated a lot of really great discussion at our meeting, but the subcommittee voted pretty consistently that this should not be subject to professional discipline. But again, we are dealing with this sort of, I guess, evolving standard, right? This question of, is this something that when you're engaging in conduct that you knew, or more particularly, you should have known that these particular words were not okay? That's what I think generated the great conversation in November. But because ultimately these particular phrases, these particular words and descriptors they are conduct that manifests bias or prejudice. And again, we get into this question of context. Is it somebody who just had no idea? And there's kind of I guess, when you look at that person objectively and reasonably, that you can understand and appreciate that they did not know, versus somebody who truly should have known because they've been around, based upon the conduct itself, the word used, perhaps just a number of different factors that could play in there. But ultimately, we're hitting back once again at this question of mindset, know or should have known, as well as the conduct itself that manifests this bias or prejudice. And this is our last one. Carmen?
Yeah, this one's difficult. This is the one I think we struggled with the most. And it's clear from the response of the subcommittee in the first instance that you all struggled with it a bit too. This is an outrageously offensive comment by a lawyer to a couple of three friends who are lawyers. So that's our context. And the comment is directed towards another participant in the legal system. But other than that, there is not a lot of nexus with professional activities. And I think that was one of the things that we struggle with in the discussion. Now, the actual case that this was based on had a few additional facts that I think were probably dispositive, honestly, in allowing the state bar to take action, which is that these were government lawyers who were using state issued, equipment, or actually it was email. It was an email chain. So they were using their state email addresses and having these, I'm not going to call them conversations. They were doing this during work hours. And so that hook, I think, is what allowed this fact pattern to fall within the regulatory purview. We really struggled with how we would cover this. Not the second piece so much. I believe that the definition that we proposed of acting in a professional capacity could probably cover the same scenario that was actionable in the underlying case from this hypothetical. But when it comes to just the conversation between lawyers who are friends, that the only thing we could come up with that would allow that to be regulated would be modifying Rule 4.4, as Brian mentioned earlier, to include conduct that has no substantial purpose other than to demean a person involved in the legal process. The existing categories of, embarrass and burden in Rule 4.4 didn't seem sufficient. And we felt like we would have to have some other word in there that captured this conduct. So I think this is a very difficult one. And the fact that it's so difficult may reflect that it is not the kind of thing that is subject to regulation. If it's nearly impossible to create a rule that makes sense, that probably tells you something.
Yeah, but the more reprehensible the conduct, like I agree with you, Carmen, that the existing rules probably don't cover that. But if there could be a slight modification to Rule 4.4 that arguably would cover that, I mean, I'd certainly be in favor of it. I mean, once again, it's not in the professional capacity, but it is conduct that is just so offensive and reprehensible that it should be. And maybe I don't know. It's pretty offensive and reprehensible.
All right.
So that's the end of our recap.
Yeah. So we from all these different hypotheticals, we identified a couple of different components that seem to appear time and time again in the hypotheticals, as well as in your responses via that vote. State of mind, again, that somebody, they knew or should have known that their conduct ultimately, I guess going down to a part a little bit further down, that it manifested bias or prejudice, but that mindset of knew or should have known seems to be the most appropriate thing, and especially considering the different constitutional considerations that we previously covered, both in law review articles as well as other states' versions of the rule. The prohibited conduct, as far as employment discrimination, like we said before, tie that in those employment-related issues to existing law. That's going to be probably the most straightforward way to do that. Whether or not there's an adjudication that's required first is something that's up for debate in this subcommittee. Sexual harassment is going to be separately addressed as well. And then, of course, the conduct that's manifesting bias or prejudice. That's ultimately what we're getting at when we talk about not necessarily employment discrimination, but just discriminatory conduct, demeaning conduct based upon a personal characteristic. The things that the hypotheticals kind of showed we want to exclude from the rule are things like social functions, good faith CLE presentations and scholarship, legitimate advocacy, asserting some sort of good faith argument that's grounded in law, as opposed to something that is completely irrelevant and really has no other substantial purpose than to just embarrass or burden the person or demean that individual. And then social, political, civil activities that are unrelated to the practice of law should not be incorporated under the rule. And again, that's, I think, reinforced not just by the subcommittee's votes, but by our research and our discussions on that First Amendment jurisprudence out there. So I guess that really is our recap right now. And we have our proposal. I guess really it's not so much a proposal as much it's just the working draft of how we kind of cobble this together that we can discuss now. But before we move on to that, I guess I just want to make sure if anybody has any questions, then by all means, feel free to
I have a question for Carmen. The knew or should have known standard, I know we use that all the time in law, but in the Office of Counsel, is that something you all deal with all the time? Is this a new burden we're placing on you guys, or is it something you already have to consider pretty often in what you do?
Actually, so the definition of knowledge in the general definitions section of the Rules of Professional Conduct says that knowledge is, actual knowledge. However, it may be inferred from the circumstances. So we actually have, I think, a greater burden in general in establishing enough evidence to show actual knowledge. We do not get to rely on should have known. I don't think that appears in any of the rules. So, that's something to consider also. But this, in fact, I think is more forgiving in terms of proof. Does that answer your question?
Yes, thank you.
Okay.
All right. So with that said, I guess, Carmen, we want to move to the proposed, or I guess, again, I'm using that word inappropriately, the work in progress that we've put together, which you all should have in your email inbox at this point. But I will go ahead and share my screen as well so you all can see it. Just 1 second. Apologize here. There we go. Carmen, you want to introduce this?
Yes. So the way that we did this, instead of, the ABA rule is just one subsection of Rule 8.4. That's all it does. We, in this draft, followed the model that Brian proposed last fall, which is actually incorporating the notion of anti-discrimination partially into Rule 8.4 and partially into Rule 4.4. And that's what these amendments reflect. So in Rule 8.4, we try to address these two very specific limited categories. We thought that was really more consistent with the other pieces of Rule 8.4, the prohibition on criminal conduct, et cetera. These are sort of more specific types of bad acts. So that's what you have on your screen now is our proposed amendment here. This would be a new section of Rule 8.4 that specifically addresses employment discrimination as defined by applicable law and sexual harassment as defined by this rule. So, scrolling down to definitions, this is not new. This type of definition existed in some iteration in previous drafts that we've provided to you. The only part that we changed substantively is towards the end of the definition, where we clarify that participating in official business of professional organizations would fall under this, the scope of this rule, but the purely social activities would not. So that's the new piece in defining our scope here. The next definition that we propose is one of sexual harassment. This is less rigorous than the legal standard for proving employment discrimination based on sexual harassment. It probably needs to be modified and improved. I mean, Brian and I suggested we could have a whole separate working group just to come up with this definition. But as I mentioned during our previous discussion, what we tried to do here is at least limit this definition so it wouldn't include a single instance of an inappropriate comment. We just don't, it just seems like too much. So that's the definition we've suggested. So I don't know if anyone has questions or comments just about that first piece. I don't know how we should do this exactly. It might be helpful to discuss some of it when it's on the screen, but I don't know.
Steve, I think you're on mute.
I have two thoughts on the definitional part. In a professional capacity, would a person who's being investigated or accused of this conduct would have an out if it weren't listed? There's no catch-all, and maybe that's a good idea, but it's just something that sort of popped out at me. We say one thing it does not apply to, we say several things that it does apply to, or people that it does apply to, context, as it were. The second thing is on sexual harassment. I would add the word objection to reciprocation, despite lack of objection or reciprocation.
So
I'm getting too far down in the weeds.
Or do you mean despite objection or lack of? I'm trying to understand.
Well,
okay.
If the person who's getting these continual harassment addressed at them, objects, then
right. So lack of reciprocation or affirmative objection or something like that. Yeah, that makes sense. I think we were trying to not place the burden on the target of the conduct to affirmatively do something, and that's why we phrase it that way. But certainly, certainly when the rejection has happened, it's time to stop. Okay. So we also included, as we really think that limiting scope is the key to crafting a rule that would be constitutional. And so both of the proposals that we have here have pretty significant limitations on their scope. This one, because the rule itself only addresses these small windows of conduct, we really just have here. So here it is, Brian.
It is in there. I was wrong. Just
okay. So what we have here is a limitation on any employment discrimination as a disciplinary issue to a situation where the tribunal has actually found that it was actionable employment discrimination. So that significantly narrows any disciplinary actions for employment discrimination. And then we have just a sort of a general catch-all exclusion for conduct that is unrelated to the practice of law. So that's really our proposed change to Rule 8.4 that is very narrow. You know, I guess if we compare just this change to 8.4 to some of the other jurisdictions, this would be on the, you know, the narrower end of the spectrum. But we're not done, of course. We also have Rule 4.4. So, Brian, tell us about that.
Sure. So, and just as quick, do you want to talk about the comments at all, or we can talk about those later?
Yeah, I mean, we probably should tell the subcommittee, there are other comments that we've talked about that are included in other rules that provide more, I don't know, a sort of explanation for why this is important, but there's already so much content here. We didn't want to include all of those today. So we really only included the comments we thought were necessary in order to fully explain the rule as you all intended it to be. I don't think we need to talk about those particular comments.
Okay. So, you know, as we've been saying, 4.4 is feels like an opportunity to address, maybe just to approach this issue that we're tackling, maybe in a different, hopefully cleaner light, with 8.4 focused on employment discrimination and sexual harassment. 4.4, however, being modified to address those things that are really demeaning to other individuals. And 4.4, of course, already having this language that has been in our rules of professional conduct for some time, and it's been applied for some time. The notion that, you know, as the rule stands right now, a lawyer is not allowed to do something that has no substantial purpose other than to embarrass, delay, or burden a third person. The proposed amendment would essentially expand and modify that to the expansion being that this isn't just something where a lawyer is prohibited from doing those types of things to a third person, but also really just to a person that's involved in the legal process. That can include the client, you know, because that's something that I think we want to make sure that we're, especially in protecting the public, protecting clients, and arguably that language that limits it to a third person would not be applicable, or 4.4 wouldn't be applicable today if you're talking about a lawyer acting inappropriately towards a client. So 4.4, this new amendment would expand that. And again, we start off with conduct that the lawyer knows or reasonably should know has no substantial purpose other than to embarrass, delay, demean, or burden a person involved in the legal process. And that's where we've inserted this term. We kind of, I guess, expanded once again the scope of 4.4 to focus on this conduct that, as Carmen described before, the current terms really aren't sufficient to capture exactly what I think this subcommittee is attempting to address. Embarrassing, burdening a person, you can make arguments, but I think having that clarity, especially when we're talking about vagueness challenges and things of that nature, but we're including this word demean because that's really, I think, at the crux of the issue. We're similar to the preamble, we're talking about respect. We're talking about treating people with dignity, and a lot of this conduct that I think we've discussed in these hypotheticals and other cases is really demeaning conduct. So we go on to talk again, the prohibition includes this conduct that manifests bias or prejudice, that key term there, against a person that's based upon a person's race, sex, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. That list of characteristics is hopefully sounds familiar. That's the same list that was included in the preamble. However, I think that's something that, perhaps for a later time to discuss exactly what characteristics we think is most appropriate and how we best describe or capture those characteristics. But again, this just general idea of separating out these two types of or these different types of conduct, utilizing 8.4 as well as 4.4. That's the purpose here.
Brian, that rule violation, at least 4.4, and I don't know if it's in there or not, is triggered regardless of whether or not there was client ratification, it was at the client's directive, or with the client's consent. I get that question a lot from in different scenarios from a client or that says, well, or from a lawyer that says, well, my client instructed me or my client knew about this or ratified it. 4.4 is violated regardless of client consent or client direction or client instruction. Is that
Yeah. Yeah, I agree with that. I think that's something that, just because a client says, I want you to treat this person completely inappropriately, throw everything at them, including a bunch of, bigoted nonsense, is not something that you can kind of throw your client under the bus and say, well, I was just acting at my client's direction. So I would agree with that, Alan. Judge Rader, I see you have your hand up.
Oh, yeah, just quick question, Brian. I know when you and Carmen originally did your two separate drafts, in Carmen's draft, she took out the phrases marital status and socioeconomic status from the list of protected groups, because she said primarily because these categories do not involve traditionally protected classes and seem thematically inconsistent with the other categories. Is that, and I noticed they're in this time, I'm just curious, any thoughts about that?
Well, I'll say they're in because I guess as more of the work in progress nature, this was the list of classes that you see in the preamble that I think you see in a lot of different rules, but that is something that I think this subcommittee would be wise to discuss, to be very intentional instead of just, well, let's list all the different characteristics, because that was one of those things that I think it was hypothetical number 2, where one of the demeaning comments made was about a judge's weight and physical appearance, and certainly there are a lot of I think there's a lot of validity to just the general notion of commenting on someone's physical appearance in a very negative way can be very harmful as well and cause disrespect to be kind of garnered about that person in third persons, things of that nature. So I'm not trying to advocate for that to be included. I'm just kind of pointing out that I think each one of these classifications in composing this rule are worthy of just kind of looking at and, exactly what are we talking about and what do we want this rule to encompass.
Okay, thanks.
So the other component that we've added here for 4.4 that differs from the prior iteration is this last kind of sentence or section that says, provided, however, and this is where we get into some clarification on scope of the rule. For one, we start off by saying the thing that I think we've heard most often as far as a concern for this type of rule that clarifies, this rule does not limit the ability of a lawyer to accept, decline, or withdraw from a representation, that this does not really compel a lawyer, in other words, to take on a particular client or cause under the rules. Also, the notion of legitimate advocacy, that this paragraph is not intended to preclude legitimate advice or advocacy that's consistent with these rules, nor would it limit legal scholarship or presentations that are based on good faith interpretation of law. And particularly to note that just because someone's interpretation of the law is controversial or may be offensive to others, doesn't necessarily establish a violation of this rule. And again, I think that's one of the most often cited components, not just in that Pennsylvania case, but in other law review articles and commentary about these types of rules. Marcy, I see you have your hand up.
I just want to make sure I understand something. So in my world, in the domestic world, I have a case right now where my client, her husband just told her after 30 years of marriage, no less than that, about 25, that he's gay, and they have a child, and it's a custody case, and her religion, so I mean, we can argue as her lawyer that her position is that he should not have primary custody because he's gay, and she thinks that she should have primary custody in a more traditional home. Can we do that with this rule?
I don't know the answer to that.
I mean, this happens a lot. This
Yeah.
is not just a one-off kind of case.
No, You're right, and I mean I can think of a case out of the Supreme Court where I think that very basis was cited as a reason for, I don't know if it was terminating parental rights or a custody issue.
I think the answer, I think you just hit on the answer, Brian. I think the answer is if there is a good faith basis in law for arguing that the issue of child custody or the determination of child custody can be legally based on, lifestyle within the household or, religious convictions of the parents, I think then it's fine. I think that contrast that with the example in the hypothetical saying that this parent shouldn't have custody because she spends too much time with someone of a different race. There was clearly no legal basis for that argument or a good faith argument for the extension of law. So I think that's going to have to be how that question is answered, at least based on this working draft.
Yeah, and I think that's it's. I was about to say this is where that issue of context comes into play. What is the context for that argument? Whether it's grounded in law and you have some sort of legal basis, whether it's, I guess, the concerns that are raised with a particular lifestyle. Contrasting somebody with I guess the person that has identified now as gay and they're getting divorced because of that, but kind of expand upon that and say, well, that it's not just that, there's other additional factors that make it unsafe for the person to live there. Again, that's going to be incredibly fact specific and I guess content specific or context specific. That's why I don't really know the answer to that question. But certainly there is a legal basis in that court case that came out of the Supreme Court some, I think, 10 or 20 years ago. I don't know if anybody else is familiar with what I'm talking about.
The case that we had, the hypothetical with the black boyfriend, the attorneys in that case, parties, had stipulated that there was no nexus between the color of the boyfriend and the custody issue. Yet the attorney went ahead and argued it in closing, I think, or whatever it was. But that, I think, was an important distinction in that case. And it was a censure only, was the discipline against the lawyer there. But I think to Marcy's point, if you can make the case that this lifestyle hurts my kids, you have to make it. It's your duty to make it. But if it's not there, you can't make it.
Alan, are you trying to say something I couldn't tell?
What if your client really thinks it does, but your client really truly believes it because she's, very conservative, they really believe it even, is that enough? It's her belief, it's her religious belief.
Right. I feel personally that, this is that distinction of the lawyer not necessarily agreeing with everything that the client says. That certainly there are probably plenty of examples that folks on this call can think of where a client has asserted one thing and the lawyer says, well, no, that's just not the case. And I'm not going to bring that argument. So I think that's, don't get me wrong, this is a tough issue. I think that's based upon just the client's assertion, kind of getting to Alan's point previously of, well, my client told me to argue this, whether you're talking about this person is unfit to be with my child because of their race, because of their religion, things of that nature, that if there is no well-grounded assertion in law, then presumably this rule would cover that. But I think, again, it would have to be very fact specific. Well,
you're saying that a person who truly believes this, has this religious belief, that those people don't deserve lawyers? And the lawyers
I'm sure he's not saying that.
I'm not trying to say that at all.
The lawyers can't represent them, though. It's my point. If you, I didn't mean to say it that way, but the lawyers can't represent them without being, violating a rule.
It sounds like to me, Marcy, that they're saying is that they do deserve the representation. They should have representation, but right. The decision rests with you on how to go about that advocacy and whether it is something that is grounded in law before furthering it. I don't see that actually any different than any other, kind of advocacy that we have to do and weigh how we're going to go about it.
Yeah, that's true. The clients have a goal. but they don't get to decide the path to get there, you know. But also, Marcy, if I can suggest something, I feel like this is a great question, but I feel like that we might have a more productive discussion about it if at our next meeting we have like considered in advance more, you know, like, and maybe I'm sure there are other members of the subcommittee who have similar questions like, well, how would this apply to that or something else? And it might be, I mean, we're already at 10 after 4, so it seems like we should probably, you know, we're not going to be done with this. Obviously, we're not going to be done with this today. And I think it would be great to get some of these really hard questions before the subcommittee and have a meeting where you all just wrestle with those. So that would be my suggestion. And Brian, I don't know how, I mean, I don't know how much more you wanted to say about Rule 4.4, but it does seem like we should at least give Steve a couple minutes to like conduct a discussion.
Well, I will briefly, I don't think there's really much to discuss. There's some pretty familiar things. Sub C here about peremptory challenges is something that you've seen in a lot of different rules that alone does not establish a rule violation, as well as the paragraph not applying to a lawyer's social, religious, political, or civic activities that are unrelated to the practice of law, something that we saw in the other proposal for 8.4. I won't talk about the comment. I know we have not talked about Rule 1.19, but we referenced this before. Carmen, do you want to go through this briefly as far as our proposal?
Well, the more I thought about it as we were sitting here, the more I've concluded this subcommittee has plenty to do. It has plenty to do. I don't think you need to wander off into Rule 1.9. However, I would suggest that just based on the overwhelming opinion of the subcommittee that type of conduct about, you know, exchanging naked pictures for fee reductions should be actionable. Like, based on that opinion, I would suggest that you actually refer this back to the main ethics committee and suggest that we undertake some examination of whether 1.19 should be revised. I would, in my opinion, this amendment basically is a 21st century update to a rule that was enacted in 1997 during a period where people were not as prolifically sending each other naked photos using their smartphones. This is a real thing. I mean, I've had many cases that involve this kind of conduct, and sometimes the exchange of messages constitutes an attempt to have sexual relationship with a client, but not always. Sometimes it's just for the sake of the images, and I think that's something that the ethics committee might want to look at. So,
or you could just continue to use 8.4D, conduct prejudicial to the administration of justice.
Alan, you know I don't overuse that subsection.
I know, but I know others.
Dorothy, you have your hand up?
Yes, I have a question. Have you all considered revising that D2 where it talks about any touching of the sexual or other intimate parts, to expand that to just any parts of a person unwanted touching of that? It doesn't necessarily have to be it could be sexual in nature and not be touching an intimate part.
I agree. This conversation could get real weird real fast. But I think, so Dorothy, I think one of the reasons that we also thought this type of behavior would go in this rule rather than related to sexual harassment is that the sexual harassment definition includes the notion that it is unwanted or unwelcome. This rule doesn't include that, because the idea here is that it is inherently antithetical to the fiduciary relationship to have any kind of sexual, you know, contact or innuendo or whatever. So it doesn't matter whether it is welcome or not welcome. It's just, it's not compatible with the attorney-client relationship. So it may be that we could tweak the language of D2, but again, I just feel like we have so much to do in this subcommittee that you all might want to assign that to someone else. Just a thought.
I agree. I just wanted to throw that out there that it doesn't really cover all the type of touching that could occur that could still be considered sexual in nature.
All right, let's talk about that offline.
Talk about that in July. All right. Well, Steve, with I know we only have about 10 minutes left, but that's where we're at. So what where would you like to take our conversation at this point? Oh, I think you're muted, Steve. There you go. Oh, you went back on mute.
Am I good now? Okay.
Now you're good.
Thank you both for all the work you put in on this. That's a great presentation, and I like the way you're bringing it back to if we're going to have a rule, what's it look like, and what are we going to put in it, and what did we learn from the hypotheticals? I think beginning at the end, we should refer back to 1.19 stuff. I'm going to recommend Dorothy to chair that committee. But subcommittee, but
well, I'll definitely be assigned to staff it. There's no question about that. So
we have a lot on our plate, and we'll need to pick this conversation up in July. Totally fascinated by Marcy's hypothetical, as it were, and it really doesn't give me a lot of heartburn as to how I would handle that, but I would enjoy having a cup of coffee with Marcy and talking about it at the very least. And we can bring it to the entire committee. And there are some other specifics that have come up in today's discussion. The know or should have known standard, when we look at back to the Colorado case, one of the defenses there was, well, you know, I'm a tough guy from Chicago, and so we call people fat effing whatevers, and that's just who I am. I'm not going to change. Well, is that what should he have known, or what did he know, or what should he have known? Well, all he knows is that's who he is, was his defense. Didn't get him very far, but it can be instructive to our discussion of know or should have known. And I'm interested to hear from others as to where we go from here, but those are my thoughts on it. I think we have to look again. I had forgotten that we deviated from sort of what other states have done in terms of just lopping a rule on 8.4, and kind of admire this handiwork of getting it into 4.4, getting some of the concerns taken care of by that rule. I think it's elegant, but again, I'm interested in having some conversation, looking over the rule and where we've come from and where we're going in July. Any other thoughts?
My one quick thought would be that as a native of the Chicago area, I reject that defense. He should have known growing up there.
You didn't grow up in the tough part of town, I got a feeling.
I guess not.
You weren't that lawyer, thank God.
No, I think, and to what you just said, Stephen, really going back to what Marcy's posed, that's exactly the type of interaction with the rule that we need to have to figure out what would a rule look like, and ultimately, is it something that we think is worthy of adoption and defensible in terms of its constitutional perspective. And so I would ask if, as you all look at this kind of work in progress, if you have any other situations you're thinking about your own practices where this might be implicated, or some aspect of representing a client might be implicated, to feel free to shoot Carmen and I an email. Maybe we'll start composing some of these questions as we vet out the rule and see what tweaks, what things we need to address to clearly describe, with that being the ultimate goal, right? For constitutional purposes, clearly describing the conduct that's prohibited, and not going too broad on this, but also in a way that is respectful of First Amendment rights. So feel free to shoot Carmen and I any sort of other scenarios, hypotheticals that you'd like us to consider.
All right. Well, thank you, Brian. Thank you, Carmen, for putting this together.
It's a good conversation.
Are there any other committee members that have any comments before we go? I just want to say, Marcy, let your husband know I've got his trophy for him, and I'll be bringing it out to Asheville so that he can reclaim it.
Yeah, he's missed it. We still have the place in our lobby that it's supposed to be. It's just still sitting there waiting for it.
Yeah, that COVID really, I know, really put Lamar back a whole year besides the one.
He needed it. It's good for us. It's good for him.
All right.
Stop the stream yet, Marcy. He's going to see that.
What?
I said I haven't stopped the live stream yet.
Oh,
He's
no.
going to see that. I'll stop it now.
All right. Okay.